Hi, everybody. Thank you for joining us. My name is Daniel O'Neill. I'm one of the co-chairs of the CLE committee. This is a topic we have been really looking forward to, and we're really lucky with the speakers that we have here today. I'll introduce them in just a second, but just to let everybody know, the December CLE, which you should be getting emails from Lucy about pretty quickly, that is December 8th. And we have Austin Martin presenting on mediation in the COVID era. So for all the civil litigators, that'll be an excellent topic for everybody to check out. So just keep an eye on your emails from Lucy and go ahead and RSVP for that if you'd like to join us. So what we're here for today, this amazing presentation, attorney-client privilege and work product doctrine, is being presented by two trial attorneys, Jennifer and Brooksie. They're both trial attorneys at Shipley Snell Montgomery. We're excited for this. So Brooksie and Jennifer, if you'll go ahead and kick us off.
Thanks so much, Daniel, and for everyone with us. I'm Brooksie, and I'll be getting us kicked off today on this presentation about preserving privilege. A little bit of a roadmap so you know where we're going. I'll give you an overview of the attorney-client privilege. My colleague Jennifer will overview the work product doctrine. Then we'll walk through some case studies, both from federal and state courts, followed by a little bit of discussion on practical application. At that point, we'd love to hear from you guys in the comment feature about maybe your best practices or thoughts on the material that we cover there. And then we'll of course have some built-in time for questions at the end. But if you think of something throughout the presentation, of course, feel free to drop it in the comments box and we'll take a look at it toward the end. Starting with the very basic overview of attorney-client privilege, something we of course all learned in law school. Seems pretty straightforward, but when you actually get into practice, there can be some tricky areas and difficult decisions. Starting at the foundation, the purpose of attorney-client privilege and why we have it. The courts have said it's to encourage communication between lawyers and their clients, so lawyers can render the best possible legal advice. And what's important is that the communication be made in confidence. The purpose goes directly in to what the basis of privilege is. On the screen, you'll see both federal law and Texas law. Very similar, but an important distinction is the federal law of privilege comes from case law. You're not going to find it at any type of evidence code. The state law of privilege is codified in the Texas rules of evidence. So just taking the federal factors one by one, your communication is privileged if it's between a client and attorney or that attorney's agent, made by the client and contains confidential information outside the presence of any non-privileged third party for the purpose of securing legal advice, and the privilege hasn't otherwise been waived. Texas law on the purple side of the screen is quite similar. Something to note is, in diversity cases, federal courts do apply state attorney-client privilege law, and you'll find that in Federal Rule of Evidence 501. One of those tricky topics about privilege is how it applies to a corporation, and we'll start with how that works under federal law. Here we're really looking at who falls within the definition of a client representative to determine how the privilege applies. Back in the day, they had the control group test, and that was really difficult because the control group test said privilege only applies to your higher level executives within that corporation's control group. And many courts use the control group test to determine whether other employees within the corporate structure were covered by the attorney-client privilege. This was a much narrower test that limited the privilege to these high-level control group executives. Any lower employees were excluded from the privilege. But now, very good, the federal courts have adopted the subject matter test. And this is important because privilege can now apply to communications between attorneys and lower-level employees that aren't those executives or supervisors. And it's broader than the control group test that formerly applied. You know, for example, counsel can have privileged conversations with all employees involved in the incident. some more blue-collar workers down the line, the boots on the ground folks. And that's really important to conducting a thorough investigation. You'll see the condensed subject matter test on the white side of your screen. 2 parts there. The employee made the communication at the direction of his corporate superior, and the subject matter upon which the attorney's advice was sought by the corporation and dealt with in the communication was the performance by the employee of his duties of employment. So it's got to be within that employee's wheelhouse. On the purple side, you'll see what's called the modified subject matter test. The test does have variations. This is the 8th Circuit's spin on it for the modified subject matter test. And they're really looking at how to stop the funneling of information through counsel with the intent to make information privileged, which they get it in point number 5 about disseminating that communication beyond the people who have to know. Oftentimes I know we forward emails or add attorneys to emails, so certainly something to be mindful of if you're practicing in jurisdictions that use the modified subject matter test in federal court. Moving on to state law, you'll see that the Texas Rules of Evidence have both the control group test and the subject matter test in Texas Rules of Evidence 503. So you're covered on both fronts there. The old control group test, that's much narrower, and the subject matter test that the federal courts follow today that takes the broader, more inclusive approach. Here I've got some things that commonly come up in representation, specifically corporate representation. So if your practice includes representing companies, let's say in commercial litigation, very important things to be mindful of. But if you find yourself on the other side of the V, trying to get information from corporations, this is important for you too, so you know how to tailor your requests to get the information that you're seeking. First is the role of in-house counsel. You've always got to ask if in-house counsel is rendering legal or business advice. What's the purpose of getting that advice? One thing, very vanilla example, is providing advice in a pending lawsuit. That's going to go in your legal advice category. But a more difficult decision may be advice about whether to fire an employee. Is that legal advice, or does it fall more so on the side of business advice? The next issue is related corporate entities. When you have a complicated corporate structure with a parent company and several subsidiaries, let's say, the question is that subsidiary covered by the parent company's privilege? The answer is that it depends. You have to think about whether the parent corporation and the subsidiary function at arm's length, or maybe there's a closer working relationship where the law department is shared. If there's a shared law department, you're probably covered under the same privilege, but if you've got that arm's length type of relationship, you need to think twice about whether the sub is covered and whether perhaps as a plaintiff, you can get at some information because of that arm's length relationship. The final thing I'd like to discuss here is the former corporate employee. What happens when an employee leaves the company, let's say for a new job, but has relevant information that comes up in later litigation? Can communications with the former employee still be covered by the privilege? Generally, yes. The communication can be privileged when the former employee speaks at the direction of management with a corporate attorney about conduct that was within the scope of their employment during their length of employment. One tricky thing that I'll note is if you reach out to that former employee to perhaps engage them as a consultant or an expert in the litigation, then you can run into some issues with privilege because you're not reaching out to them as a former employee, but as an expert or a consultant. Another thing to think about is the waiver of privilege. This seems straightforward. Don't talk about confidential things in front of third parties who don't share your privilege, who aren't the lawyer or the lawyer's representative or the client or the client's representative. Something that does get tricky is inadvertent waiver. Using Texas law as an example, The disclosure has to be voluntary to waive your privilege. You know, this question can often come up in the context of, what if you accidentally produce privilege information? It happens to everybody. It's the practice of law and we all make mistakes. So what do? You have to amend your response, identify the material or information produced, and state the privilege asserted within 10 days or a shorter time ordered by the court after you discover the inadvertent production, that a document accidentally slipped out in a large set of documents, let's say. And you'll find your authority there at Texas Rule of Civil Procedure 193.3D. Some factors considered by the case law, these are pulled from a federal case, but Texas state courts look at a similar analysis. And this is what you look at to determine whether the inadvertent production, let's say, disclosure, was actually voluntary. First, the reasonableness of precautions taken to prevent the disclosure. Did you have a good system in place? Were you being careful? Or did you just haphazardly forward some documents in a set that you received from your client without actually taking a look at them? 2, amount of time taken to remedy the error. Did you quickly discover this within a matter of days, or has it been 6 months and you're now getting ready for trial? A good practice pointer might be to take a double check, take a spin through your production after it's been sent to opposing counsel, just to make sure you didn't accidentally let anything through the cracks. Finally, they also look at the scope of discovery and the extent of disclosure and overriding issues of fairness. You may also want to look at Federal Rule of Procedure 502 and Texas Rule of Evidence 511. They'll get into some other scenarios like disclosures made in state and federal proceedings, effects of court orders, and certain party agreements, if you need to take a deeper dive into this for any reason. Now I'll turn it over to my colleague Jennifer for an overview of the work product doctrine.
So now we're going to turn to the more narrow protection of the work product doctrine. The work product doctrine generally protects from discovery by an adverse party any materials prepared by or for a party in the anticipation of litigation. In order to assert this protection, the party claiming the work product privilege must prove that the materials in dispute are, first, documents and tangible things, 2, that were prepared in the anticipation of litigation or for trial, and 3, that they were prepared by or for the party's representative. An important practice tip to note in federal court is that in diversity cases, the issue of whether documents are exempt from discovery under the work product doctrine is actually governed by federal law. That's because the courts interpret it as a procedural question. The most difficult element to meet in order to establish a claim for work product privilege is establishing whether or not the document was prepared in the anticipation of litigation. The federal courts utilize a number of different tests in order to make that determination. The first test that the courts utilize is the because of test. In this test, the courts analyze whether under the facts, the document can fairly be said to have been prepared or obtained because of the prospect of litigation. This is the majority test, and it is actually the easiest test to meet. The next test is the primary motivating factor test, and this is the test that the Fifth Circuit Court utilizes. Here, the party must show preparation for litigation must have been the primary motivation for the creation of the document. The final test is the for use in test. This protects only documents created specifically for use in litigation. This is by far the most restrictive test, but it is limited to just a few jurisdictions. The Texas courts utilize a two-part test. The first piece of the test is the objective piece. Under the objective piece, the court's trying to determine whether a reasonable person would have anticipated litigation under the circumstances. The second piece of the test is a subjective piece. There, the court is trying to determine whether the party trying to keep information confidential believes in good faith that there was a substantial chance that litigation could happen and that they made the document to prepare for that possibility. It's important to note that Texas courts recognize that even though the investigation must be conducted for the purpose of preparing for litigation, Rule 192.5 does not require that the primary purpose of the material or the communication be for preparing for litigation. Here, the courts have held that a substantial chance does not refer to any particular statistical probability that the litigation will actually occur. What they're really determining is that is litigation more than a mere abstract possibility or an unwarranted fear? In reviewing this rule and as applied to accident investigations, the Supreme Court of Texas actually rejected that the circumstances surrounding an accident can never by themselves be sufficient to trigger the privilege, and instead stated that if a reasonable person would conclude from the severity of the accident and other reasonable circumstances surrounding the accident that there is a substantial chance that litigation would ensue, then the objective prong is satisfied. The court must next assess what type of work product that document constitutes. There are two kinds of work product. The first kind is the opinion or core work product, which includes mental impressions, conclusions, opinions, or legal theories of an attorney or other representative of the party concerning the litigation. Examples of this category would be investigative reports that contain summaries of witness interviews. Courts have even found that documents that were specifically selected and compiled by a party or its representative in preparation for litigation may be protected. That's because selecting specific documents and compiling them into a set shows the representative's mental impression, and thus these documents as a set would not be discoverable. That's compared to the ordinary or other work product protection. This includes all attorneys or other representatives' materials that do not contain the mental impressions, conclusions, or opinions of the individual. It's important to note that documents and materials assembled in the ordinary course of business or pursuant to public requirements unrelated to the litigation are never protected as work product. If a document constitutes work product, the court must also analyze whether the other party has met its burden in showing that there is an exception to the non-disclosure of work product. The exception arises when the party seeking discovery can show that it has substantial need and may suffer undue hardship if the document is not disclosed. Specifically, if the party seeking discovery can show that it has a substantial need of the materials in preparation for its case, and that the party would be unable without undue hardship to obtain the substantial equivalent of these materials by some other means, the court may order production of the document even if it qualifies as work product. However, even when the requisite showing has been made, the court will still protect against disclosure of the mental impressions, conclusions, opinions, or legal theories of an attorney or the other representative of a party concerning the litigation, which, if you recall, is that core opinion work product category, that first category. Under Texas law, the protection of this core work product is provided an absolute protection. However, it has been noted in a Southern District of Texas case that the Fifth Circuit has not made a ruling regarding whether this type of work product is provided an absolute protection. As such, there may still be an argument that that type of information may need to be produced, even if it requires some sort of redacted format to take out the specific mental impressions of the attorney. The final key piece to keep in mind with work product protection is when and how you may waive that protection. Waiver of work product protection only results if the work product is disclosed to an adversary or treated in a manner that substantially increases the likelihood that an adversary will come into possession of that material. Unlike the attorney-client privilege, the burden on proving waiver of work product immunity falls on the party asserting the waiver. If the party is successful, waiver of the work product immunity will be limited to just the materials actually disclosed. However, it's important to note that the federal courts have acknowledged the potential existence of a full subject matter waiver. A full subject matter waiver would only be applicable if the party requesting the disclosure of additional documents can show that there is a narrow issue in dispute that would require the disclosure of all documents pertaining to this issue in order to fully understand the context of that issue. Courts have permitted this type of exception because they feel that it's in line with the reasoning behind the work product immunity, which is to protect documents, not the underlying facts contained within those documents. Now we're going to turn to a few case studies to really analyze and apply the rules that we just went through. The first case is Smith v. Diamond Offshore Drilling. This case arises from an industrial incident in which plaintiff initiated suit to recover his damages. During the course of discovery, plaintiffs requested statements from witnesses and any investigative or accident reports in the defendant's possession. Defendant argued that these witness statements and any investigative reports did not have to be produced under the work product doctrine. In order to determine whether the documents were protected from production, the defendant had to submit the witness statements and the investigative reports to the court for an in-camera inspection. As such, there were two main categories of documents at issue in this case, and we'll take each category in turn. The first documents at issue were the witness statements. The court found that these statements appeared to be nothing more than transcripts of recorded interviews of certain employees of defendant who actually witnessed the plaintiff's accident. Although the interviews were conducted by the defendant's investigator, and the interviews were taken just 3 days after the accident. The second category of documents are the investigative reports. There were actually two separate reports. The first report was just taken 2 days after the accident, and then a second report was taken about 2 weeks after the accident. Both of the reports were taken by the defendant's investigator. As such, the court now has to analyze two key questions in order to determine whether these documents should be protected from disclosure under the work product doctrine. The first question is, were the documents prepared in the anticipation of litigation? And if you recall, this means the court needed to determine whether the primary motivating factor behind the creation of the document was to actually aid in possible future litigation. And if the court determined that the documents were created in the anticipation of litigation, the court must next assess whether the plaintiff has a valid claim to have the documents produced under the substantial need and the undue hardship exception. The court took its analysis of these documents in turn, starting first with the witness statements. The court determined that since the witness statements were created just a short time after the accident and taken by the investigator, they were clearly created in the anticipation of litigation. Next, the court needed to determine whether the substantial need and undue hardship exception applied. The court determined that statements taken shortly after an accident constitute a unique catalyst in the search for truth, and that they provide an immediate impression of the facts that cannot be recreated or duplicated by a deposition that relies upon memory. And given the lapse of time since the accident and this pending lawsuit, the plaintiff could not obtain similarly accurate descriptions of the accident by just interviewing the crew members at this point in time. As such, the court held that plaintiffs did have a substantial need for the statements and obviously could not obtain their substantial equivalent by any means than through the defendant. Therefore, the court held that the defendant must produce these documents under the exception. Next, the court reviewed the investigative reports. First, they had to determine whether or not these documents were created in the anticipation of litigation. And for similar reasons, including that both of these reports were taken just a short time after the accident, and again, that they were taken by the investigator, the court determined that they were also created in the anticipation of litigation. Next, the court needed to determine whether or not the substantial need and undue hardship exception applied. The court found that the investigative reports contained analysis of the plaintiff's accident done by the investigator. It included the investigator's on-scene attempt to verify boom angles of the crane and the crane's loading handling capacity as reported by the plaintiff at the time of the accident. In addition, the reports also contain the investigator's summaries of his interviews with various witnesses. Therefore, the court determined that they were clearly suffused with the investigator's mental impressions and conclusions. As such, these clearly were opinions or core work product rather than just ordinary work product materials. As such, the court held that the document should be protected as core work product. The next case that we're going to turn to is the Zenith Insurance Company versus Texas Institute for Surgery. This case arose from a patient suffering a life-threatening injury as a result of complications from a surgery. The patient's employer's workers' compensation insurance carrier was the individual that ultimately brought suit against the hospital for negligence. Plaintiff filed a motion to compel regarding the defendant's refusal to produce 56 emails spanning multiple different categories. At this point in time, the hospital had turned over only 8 emails, including only 3 pre-litigation emails. In assessing the plaintiff's motion to compel, the court held that the general allegation of work product protection is insufficient to meet this burden. Instead, a clear showing must be made which sets forth the items or categories objected to and the reasons for that objection. The proponent must provide sufficient facts by way of either detailed affidavits or some sort of concrete evidence that enables the court to determine whether the documents constitute work products. And although a privilege log and even an in-camera review of the documents may assist the court in conducting its analysis, a party asserting the work product exemption still must provide a detailed description of the materials in dispute and provide specific and precise reasons for the claim of protection from disclosure. For purposes of this review, we're just going to focus on 2 key categories of documents reviewed by the court. The first documents at issue were emails with the insurance carrier. These are emails between the insurance broker and the hospital, including details of the patient's claim and even required forms that needed to be filled out by the hospital emailed back and forth as part of the incident and the ensuing representation by the insurance carrier. The insurance carrier noted that none of these emails had any attorney involvement. The other category of documents are internal emails. These were just emails between hospitals' non-attorney executives regarding a number of different concerns. The first is analysis and recommendation regarding their insurance coverage and a strategy regarding defense with their insurance broker. The third category is responding to media inquiries about the issues. And 4 is their strategy that they were going to employ for their own media coverage. Many of the emails within this category were authored before the hospital's liability insurer appointed counsel to defend the hospital, and there was no showing that any of these withheld emails were ever sent to an attorney. Next, we're going to review the parties' arguments regarding whether or not these documents were discoverable. First, for the emails with the insurance carrier, defendant argued that these documents were created primarily to aid in possible future litigation and not in the ordinary course of business. Defendant focused on the fact that these emails were in regards to the patient's injuries and any potential claims that may arise from the injuries. So the primary motivating purpose was clearly for the preparation for potential litigation. However, plaintiff contended that clearly the primary motivation for the hospital and the insurance carrier was simply to fulfill contractual obligations, such as sending that form back and forth for ensuing coverage to even begin, and in connection with its liability insurance, and not actually to aid in possible future litigation. Again, the plaintiff pointed to the fact that the insurance carrier hadn't even retained legal counsel at this point in time. In regards to the internal emails, defendant claims that the hospital clearly anticipated litigation following the plaintiff's surgery because the surgery resulted in a significant, unexpected outcome with potentially life-threatening complications. However, the plaintiff countered that all of the emails appeared to be nothing more than routine electronic conversations between corporate executives discussing just random facts and circumstances of the medical care and maybe even ensuing consequences, but they weren't necessarily focused with an eye towards litigation. Now we're going to look at how the court actually reviewed and determined whether or not these documents needed to be produced. First, the emails with the insurance carrier. The court held that defendant met its burden to establish the documents were created primarily to aid in possible future litigation and not in the ordinary course of business because they were specific to the patient's injuries and potential claims that may arise from those injuries. But ultimately, the court found that plaintiff's argument for a substantial need and undue hardship did not meet its burden to require production. The court found that plaintiff did not show substantial need for these materials to prepare for its case, and that it cannot obtain substantially equivalent materials by other means without undue hardship, such as depositions of the individuals involved in those communications. since the court found that the substantial need and undue hardship exception did not apply, it felt that it did not need to determine whether or not these documents fell under either core or ordinary work product because the plaintiff is not entitled to either type of work product. Next, turning to internal emails. In order to more efficiently assess these documents, the court actually split them into two categories of documents, which is how we will also review them. First was categories numbers 1 and 2, and those were the documents regarding insurance coverage and an actual strategy regarding the defense that the insurance company would be providing. As such, the court found that the defendant met its burden to show that these documents were created primarily in anticipation of litigation. However, the court found that to the extent that all or any portion of these documents are ordinary work products that do not reflect an attorney's thoughts, analysis, or impressions, plaintiff has not shown a substantial need for these materials to prepare for its case, and that it cannot again obtain substantially equivalent materials by other means without undue hardship. So therefore, the court again held that these documents were protected by the work product. The second category is documents numbers 3 through 4. These were in regards to the media coverage and strategies that the corporation wanted to use to deal with the media. The court found that the defendant had not established that even though the documents were motivated by then existing litigation, that they were created primarily to aid in that litigation. Again, the court was focusing on what was the primary motivating factor for creating these documents, and was it to actually aid in the potential litigation. As such, the court here is making a distinction between documents that are just created because of ongoing litigation, but not actually to further the case within that litigation. Therefore, since the court found that the defendant did not satisfy the primary motivating factor test, the documents were clearly not protected from disclosure. And now I'll turn it back to Brooksie for our last case study.
I'm going to walk through NRA Fairway Methanol with you guys today. Before we jump in there, I know we're about halfway through the presentation, and I'd really ask for your attention, especially if you're a practitioner in Texas state courts. This is a very, very important case for those of us practicing in Houston. It came out of the 14th Court of Appeals in 2017, and it really summarizes Texas law on attorney-client privilege and the work product doctrine all in one neat package. It's got a lot of detail that is outside of the scope of today's presentation, but we'll certainly hit the high points on what the Texas courts are saying about the privilege and the work product doctrine, and look at a fact-intensive approach as well. This case covers what happens to employee injuries when there's comp coverage, also related entities, looking at that tricky corporate issue of the corporate parent and subsidiaries. And it also gets into some questions about what is litigation? Is it a case filed down at the district courthouse, or does it also encompass regulatory and workers' comp proceedings? So with that, let's jump in with a little bit of the factual background. The employee was injured on the job. He worked for Celanese Limited. The employer also owned the facility where the employee was injured. Then you get into your question of these tricky corporate entities. There were two other Celanese entities, Celanese Corporation and Celanese International Corporation. Also, name of the case here, Fairway Methanol. That's a separate joint venture outside of Celanese's corporate structure that was producing methanol at the employer's facility. So, right after the plaintiff was injured, in-house counsel for Celanese Corporation Law Department that oversaw all of the Celanese entities and provided legal advice for the entire corporate structure requested that an investigative team provide the company law department with information to assess the potential litigation and start strategizing legal theories and defenses to any claims in anticipated legal or regulatory proceedings. As requested by counsel, company employees who were supervised and directed by in-house attorneys, plus they had some guidance from outside counsel, conducted some interviews, did some site inspections. Then they report back to counsel with their findings and a root cause analysis. At some point in the timeline, Mr. Injured Employee files a lawsuit, not against Celanese Limited, his employer and owner of facility that was covered by workers' comp, but the related corporate Celanese entities, and also the joint venture, Fairway Methanol. They go back and forth with your traditional written discovery. In the course of that process, Fairway Methanol produced about 11,000 documents. They did assert some privileges, but as far as the investigation requests, they actually said that they didn't have any responsive documents or information because they didn't participate in the investigation. That was run by the Celanese Law Department. Celanese, on the other hand, produced about 42,000 documents. They also asserted privileges and withheld documents. What really gets this teed up is the documents about the investigation. You'll see on your screen the documents at issue. All of them relating to the incident, investigation reports, statements that were taken as part of the investigation, and any documents related to interviews conducted by the company. So these requests clearly get at that investigation done at the direction of the company law department by company employees shortly after the incident. The district court looked at this on a motion to compel and ordered both of the entities, the Celanese companies and Fairway Methanol, to remove their attorney-client privilege and work product objections and produce the documents responsive to the requests for investigation materials. So that's how we get to the appellate court. Issue one that we'll take first is, are these documents on the investigation attorney-client privilege? And I've laid it out for you with the employee's argument and then the employer's argument. And we'll take them one by one, point and counterpoint. First question has to do with the definition of lawyer's representative under Texas law. The employee said that the employer had not proven their investigative team was under the supervision of in-house counsel to qualify as a lawyer's representative, to which the employer responded that, of course, the investigative team was their representative because they were employed to assist with the rendition of legal services. Factors they pointed to: the team was supervised and directed by counsel, and again here, primarily in-house counsel, but they also engaged outside counsel early. And these folks were immediately informed of the purpose of the investigation, and they were told to mark all communications and documents with those magic words that we all love to use: privileged and confidential, or attorney-client privilege, attorney work product. Next point they debated here is whether that investigative team also fell under the definition of client representative. The employee said that definition only includes someone with authority to actually hire counsel and act on counsel's advice. So you should be thinking here about that control group issue, right? Higher level executives that would have that authority, not lower level people. The employer said, of course, the investigative team was also the client representative. They were doing this investigation in the course and scope of their employment. And the final issue within the broader debate over whether the privilege applied was whether the communication was for the primary purpose of legal advice, not just business advice, one of those tricky things when corporate counsel's involved. Employees said here the primary purpose of this investigation was to prevent future accidents and improve safety policies and procedures, much more general than a specific investigation tailored at the incident itself. The employer countered with saying that the primary purpose of this investigation that started the day after the incident was to prepare for any anticipated litigation. It was just a secondary concern to let the legal department know about some general business advice and also some potential legal advice on whether any of the employees involved needed to be terminated. So let's look at what the court said. Yes, the privilege applies. So taking those points one by one that were put forth by the parties, the definition of lawyer's representative, the definition of client representative, and the purpose of the communication. So takes us back to the Texas Rules of Evidence, looking at whether the investigative team was the lawyer's representative, and looking at that black letter law, somebody employed by the lawyer to assist him or her in the rendition of professional legal services. The court said yes, the investigative team fell within this definition. They really looked at an affidavit that was provided by Celanese in-house counsel, and it said, quote on the screen there for you, "The investigative team was at all times supervised and directed by attorneys in the company legal department." So that's something to think of early on in whether you're looking to conduct some type of investigation. How do you set this up, and who might need to, let's say, put forth an affidavit if litigation actually does happen? Next, on the definition of client rep. Yes, the investigative team was also a client rep. Again, looking at Texas Rule of Evidence 503, that definition on the screen for you. Anybody who, for the purpose of effectuating legal representation for the client, makes or receives a confidential communication while acting in the scope of employment for the client. Also looked at the subject matter test, whether the communication is made at the direction of superiors in the corporation, and the subject matter upon which the attorney's advice is sought by the corporation and dealt with in the communication is the performance by the employee of his or her duties of employment. So you see here the court rejecting that more narrow control group test in favor of the subject matter test. Finally, on the purpose, which is also important, the communication between the company law department and their employees who were investigating was made for legal services. You'll see here that the court rejected the primary purpose test used by federal courts and said it's not necessary that the primary purpose of these communications was legal advice. It's okay that some other things were going on there, potentially considering whether somebody needs to be fired or improving on general safety practices. Now we'll turn to the work product doctrine and whether the communications and documents are also protected by the work product doctrine. Again, I've got the employees' points laid out on the left, employers on the right, and we'll take them point by point. Very basic, again, going back to things we learned in law school. Were these investigative materials prepared in anticipation of litigation? Seems simple, but perhaps not. Of course, the employee said, no, they weren't, and the employer said, yes, they were. Now we get into the Flores test, that objective and subjective prong that Jennifer covered in her overview of the work product doctrine. And looking at the objective prong, the employee argued that it was not met, because there was no evidence of an outward manifestation that would indicate to the employer that litigation was imminent when it performed investigation. Again, this investigation started the day after the gentleman was injured. At no point in that 24-hour process did the employee say, hey, I'm going to file a lawsuit. The employer's response on the objective prong was that it is met because it was apparent from the severity of the injuries that the employee would likely incur damages over and above comp coverage. So a reasonable person would say, yes, there's a substantial chance of litigation against not just the employer with that comp coverage, but the related entities as well. And that did in fact happen. On to the subjective prong of Flores, the employee said it wasn't met because the employer's protected by workers' comp. And so they couldn't have anticipated litigation. Again, as you would think after someone was injured, going file a personal injury suit in the Harris County District Court. The employee argued that administrative proceedings are not one and the same. They're not within that definition of litigation. But the employer said, yes, Flores' subjective prong is also met because they had a good faith belief of a substantial chance of litigation, and that's why they did this investigation. Some important factors here specific to the case that are good to think about if you're in-house or you are outside counsel who normally represents companies in injury litigation. The Celanese Company Law Department doesn't normally oversee incident investigations. The only reason they were involved is because of the severity of this injury. And they really believed there was a substantial chance of issues arising from workers' compensation, personal injury, and OSHA proceedings, another regulatory issue there, based on the severity of the gentleman's injury. Finally, the employee put forth the argument that he had a substantial need for some of this as non-core work product that he couldn't get by any other means without some type of undue hardship because of how badly he was injured and how much time had gone by since they filed suit and teed up these discovery issues. So what the court's ruling is going to come down to is the meaning of in anticipation of litigation, something we bandy around all the time as litigators, and the substantial chance of litigation. Here, they also side with the employer that yes, the work product doctrine applies. Let's look a little bit at why. The documents were prepared by the employer, counsel, and representatives in anticipation of litigation and also contain counsel's mental impressions, opinions, conclusions as legal theories. So here, not just the attorneys with the company law department, but also their agents, their representatives. Then looking at that two-prong Flores test, it had been met, both objective and subjective, because objectively, a reasonable person would have concluded from the totality of the circumstances surrounding the investigation that there was a substantial chance that litigation would ensue. And subjectively, the company, the party resisting the discovery request here for those investigative materials, believed in good faith that there was a substantial chance that litigation would ensue and conducted the investigation for the purpose of preparing for that potential litigation. On the issue of substantial need, the court said no, there was no substantial need here to get at the employer's non-core work product, and the employee didn't show that he couldn't get the substantial equivalent by other means without some type of undue hardship. Factors the court looked to here were how much time had passed between the injury and filing of suit. The court said the employee filed suit quite shortly after the incident, so there was no type of argument on that basis. And just because the gentleman was badly injured didn't qualify for some type of substantial need or undue hardship. That's not sufficient in itself. And had either of those facts been sufficient, the court also mentioned that this non-core work product was also protected by the attorney-client privilege. So it had two layers of protection there, work product doctrine and attorney-client privilege. So again, I'd like to leave you with this is a very important case for those practicing in Texas state courts and really neatly summarizes the law on attorney-client privilege and the work product doctrine. The facts are quite analogous to what you'd normally see in an injury case from plaintiff's perspective or defense perspective, of course. And it really includes a lot more detailed analysis on some of the topics we've briefly covered in this presentation and takes a deeper look at some sub-issues with lots of supporting citation. So it's a great resource to keep in your toolbox. I'd say from my perspective, key takeaways here, privilege applies to employers covered by workers' compensation insurance, also extends to company employees outside of that old control group test. It also covers subsidiaries when corporate structures share a company law department and extends to those other proceedings as well in your more administrative regulatory categories like workers' comp or any type of OSHA situation. And I really think this also means that Texas courts, at least here in Houston, won't lightly find an exception to the work product doctrine. Something else to note, of course, is how early these attorneys from Celanese were involved. Early attorney involvement and investigation run by an attorney or overseen by an attorney at their direction can help establish privileges in litigation. And if you're on the plaintiff side, representing an injured employee, that's certainly something to look at. When did the attorneys get involved? I'll take a break now and pass it back to Jennifer for some practical application based on both the case studies and the black letter law and case law that we covered earlier in the presentation. I understand that the Zoom chat feature is up and running. So if you'd like to chime in at any point, this is the place that we'd love to perhaps compare some notes on how outside counsel handles certain matters for their clients, or for those folks on the in-house side, how you like to see things done.
So first, we're going to discuss privilege considerations to keep in mind during an investigation. There are a few key considerations that you may want to keep in mind once the investigation has occurred. One of the first things you're probably going to want to consider is, what are communications during an incident investigation going to look like? You may want to recommend that the client engage counsel early in their internal investigation. Recall, when the timing in which counsel becomes engaged is clearly a factor that courts consider when trying to determine whether documents were made in the anticipation of litigation. So having counsel involved is actually a factor that may bolster your work product claim. Additionally, you want to consider who should be involved in the incident investigation. Really be sure to include only necessary personnel. The more people involved, it may actually call into question whether the communications or the documents are actually protected. Specifically, including more business type personnel in making documents, it may make the document appear to have been created in just the ordinary course of business, which again, if you recall, those type of documents are never protected under work product privilege. As such, something you may want to consider is using verbal communication. That's typically preferable. Again, if there's no document to discover, then there's no need to assert a work product protection. Another key piece you want to remember is being cautious on how you're utilizing the attorney-client work product notation or objection. You don't want to utilize this designation or objection unnecessarily on every document or in response to every discovery request made by opposing counsel. Not only does asserting this protection call attention to those requests or documents, but it may require a more in-depth review of those documents. You may have to create something like a privilege log, which requires you to clearly state the basis of your privilege, and you may even have to submit the documents for an in-camera review by the court. Again, an overuse of this designation may even undermine your credibility with the court and opposing counsel, and this would call into question any subsequent documents in which you claim one of these protections. Another big issue that we typically see during an investigation is how people are utilizing and maintaining routine incident forms. A lot of clients typically have a business type form that they require their employees to fill out following an incident. They're trying to really capture witness statements so that they can do their own internal investigation and maybe even change procedures moving forward. However, this creates a big issue for attorneys down the line to be able to claim that these documents were created in the anticipation of litigation, because documents prepared in the ordinary course of business are typically held to not be prepared in the anticipation of litigation. And since these standard form documents are being used and filled out no matter what incident has occurred, it makes them seem much more to be ordinary course of business type documents. However, the courts may still recognize some exceptions for these type of forms, but it really depends on whether or not you have a good argument based on the severity of the incident and the time of the filing of the lawsuit that filling out these documents really falls under that anticipation of litigation. So the best practice is really just to treat these documents as discoverable. As such, you may want to make sure that the person filling out these documents keeps a couple things in the front of their mind. The main key thing is focus on the facts. The key thing to remind clients when filling out these type of ordinary business documents is to stick to facts and avoid any unnecessary speculation. Tell them that this is just the beginning of the incident investigation. So there's no reason that they need to jump to conclusions or the causes of an incident at this stage. Those types of things really should not be included in those standard forms. That information is better conveyed with the attorney during a verbal witness interview where the attorney is trying to do a fact-finding inquiry. So you should make sure that the individuals actually filling out these forms recognize the difference between like opinions and speculation versus the facts that actually occurred at the scene. Even though there may be a valid argument that these documents are protected from disclosure, overall the best practice is really just to treat these forms as discoverable and avoid speculation. The last piece of the investigation you may want to make sure you have a plan for is how you're going to obtain and record witness statements. This is really the tricky piece in the investigation process because it seems to be where most courts agree that witness statements following an incident were clearly obtained in the anticipation of litigation, but the issue arises when the party requests disclosure of the document is trying to make an argument that they have a substantial need for the document, and if the document is not disclosed, they will suffer undue hardship. This is really going back to that Smith v. Diamond offshore drilling case we discussed. There, the court recognized that witness statements taken a short time after an incident constitute a unique catalyst in the search for truth, and thus they may require production of at least the witness statement. Therefore, you really need to have a game plan on who is taking the witness statement and how they are taking that witness statement. There are really two potential options, and each have their own benefits and drawbacks that you really want to take into consideration and kind of come up with a plan on the type of procedure you're going to move forward with. The first option is to have the witness statements embedded with your attorney's notes and impressions. If you're going to take this approach, you really need to avoid direct quotation from the witnesses. Just focus on summarizing what they were saying. You want to add impressions of the witness and comments on what the witness is saying in order to reflect your own mental impressions. If you kind of take this approach, you're able to support an argument that the entire document is actually core work product. And that's because if the court finds that the witness's statements are so embedded with the attorney's mental impressions, then they may say that the entire document needs to be covered by this core work product and not discoverable. However, we have seen where some courts still require the production of at least the witness statement piece of this document. And the way that they kind of deal with that is requiring redaction by the attorney of their mental impressions. And this is where it becomes a really difficult process. You have to focus on and really pull apart the facts from what is your mental impression. And the concern there is that if you forget to redact something or you miss a redaction, that could result in inadvertent disclosure of some sort of core work product. And remember, this may become an even bigger issue if you're in federal court because there's this potential argument out there for full subject matter waiver. That only applies, if you recall, when there's facts relevant to a narrow issue and dispute. So it is a very hard burden to meet because the individual requiring disclosure has to show that there's this key issue out there, and therefore they need all documents related to this issue to really understand the context of the one document you accidentally disclose. However, it is still a potential, so keep that in mind if you're going to select this approach. The other option is to separate your attorney notes from your witness statements. That would require keeping like a straight log of the witness statements or even recording the witness statements on a separate document or through separate technology. Now, the issue with that is those straight witness statements are much harder to send as core work products. Again, you may still be able to make an argument that the selection of the pieces that you chose to write down show your mental impressions. But again, the whole purpose behind this protection is to keep that adversarial system alive, not actually to protect the facts. And so most courts are going to require that those pieces be disclosed. However, the benefit of this approach is that it's easier to produce those witness statements and you don't have any concern of accidentally disclosing this core work product, which could lead to actually requiring disclosure of even more information. So those are just a couple of the key things to keep in mind during the onstart of a potential investigation. Now I'm going to turn it back over to Brooksie to discuss when that investigation actually turns into a litigation.
So part two, where it really gets fun after that lawsuit is filed. And some of this, of course, has a bit of a defense perspective to it, but I spent the first part of my practice as a plaintiff's attorney representing primarily injured individuals. So this advice certainly cuts both ways and things to think about regardless of the nature of your trial practice here. So first things we'll start with are preserving documents through a litigation hold. You know, if you're on the corporation side, consider when to send that notification out to those involved in the incident. You know, consider sending it early. Of course, having it in writing so everyone's on notice of the possibility of litigation. And who do you want to include here? You want to include everybody necessary, everyone involved, but you certainly don't want to cast the net too wide if that's not necessary. And really important point, a lot of information packed into document retention, storage, and retrieval. On the in-house side, you want to think, what's our document retention policy? How long do we keep things? Does this need to be refreshed? Do we need to take into consideration any new court guidance on best practices here? As outside counsel, you of course want to know what your client's document retention policy is to know how far back they might have certain things if the litigation arises from something that's been going on for quite a long time, and perhaps, let's say, not an injury case that's happened within the past couple of years. And on the plaintiff side, you also want to have an idea of what the corporate document retention policy is to know what you might find on the other end of your discovery requests. You know, if you want to ask for something for a very lengthy time period, it may just be that the company doesn't keep those documents quite so long. The next point there is storage. How do you want to keep your documents? You know, when that litigation hold goes out, do you want to go ahead and ask people to keep them locally, or do you want to do something a bit more formal? And that, of course, goes directly into the retrieval process of how best to manage document retrieval and collection when you do get into that litigation phase and get your first set of discovery requests where you've really got to start digging into the documents and getting them from the employees, the custodians of record, all the way over to counsel for review, then ultimately production to opposing counsel. A point to note here for those of us more on the defense side or in-house, of course, is considering collecting documents early in a claims file, because it's possible that the compilation itself can lend itself to being work product because it shows that attorney's mental impressions on which documents are key and should be stored. Plus, early collection also helps figure out what documents exist, what documents are out there, and which groups of people are involved if it's a larger structure with different departments and different moving parts. And after you get through the notification steps, making sure you've got all your documents and jumping into that document review, getting ready to actually make that document production, asserting privileges. And that's clearly what we're here to talk about today, but actually doing it can be a little bit different in your written discovery responses. So, of course, your two options are attorney-client privilege and the work product doctrine. For the attorney-client privilege, as Jennifer touched on earlier in the presentation, you have somewhat of a decision to make. Also applies to the work product doctrine of using but not abusing it, right? So it's really easy for the most part to tell whether, let's say, an email is within the attorney-client privilege. You know who the attorneys in the case are, both for the company and also outside counsel. So that's really usually not a huge question mark. You know, if you see an attorney's name come up on an email thread and you see some redacted content there, wow, sure, that falls within attorney-client privilege. Something to consider as a practice pointer. In certain litigation, let's say, only part of an email thread is privileged and not the rest of it. Perhaps there was an external conversation going on, then attorneys got looped in later in the thread, and you receive an email as a threaded document. You may consider only redacting the content of the email for the parts that are within the attorney-client privilege and leaving the time and date stamp, the to from recipient list, and the subject line. I'll also generally leave the signature line. That way, whoever's on the receiving side can see, yes, that part of the email is privileged. There are attorneys on it, so no need to push back on this about whether the document is in fact privileged. Work product doctrine, of course, gets a bit trickier. One example from my practice recently is I received like an 8-page Microsoft Word document with someone's thoughts, participation in a post-incident investigation, and what they thought the cause was. Didn't have a name, didn't have a date, didn't say prepared at the direction of counsel. So of course I get into looking at the metadata, and that costs time and money for outside counsel and for the company in tracking that down of what's going on with this document. Was it prepared as part of an investigation? And ultimately had to produce the document because no one asked the company employee to do it, and it wasn't part of a larger privileged investigation. So something to think about on the plaintiff side, if you're getting a lot of objections, are when did attorneys get involved? Were these documents prepared in the ordinary course of business? And could help in pushing back in some of those work product assertions, specifically in the investigation context. And while you're asserting all of your objections, of course, and responding to your written discovery, you've got to think about that next step of making a privilege log. I know with a lot of databases today and more complex document reviews that are voluminous, you can press a button and generate a privilege log. You know, in other cases, it's still the old-fashioned way of making it line by line, document by document. But two really important points to consider here, no matter what approach you're taking to actually making your privilege log, are the roles of employees and the dates of document creation. You need to know who the people involved in these, best example again, emails are, you know, whether they're part of legal, part of claims, someone else, perhaps an employee who was on scene and subsequently part of your investigation because they were an eyewitness. So who are these people and why is the document privileged? Because these people received it and were copied on it. The other key thing is dates of document creation. Were these documents created, let's say, on the date of the incident right after it happened? Were they created maybe 5 days later once company counsel got involved? Or was it somewhere later down the line by the time outside counsel had been retained? This is important, especially from the plaintiff's perspective of seeing whether you can get at certain documents on a privilege log. If you take a look and see a document was created the day after an incident and know that the company wasn't represented by outside counsel until you filed a lawsuit, that certainly opens the door for you to make an argument that something isn't really privileged or isn't really work product. And you've always got to be thinking ahead to that motion to compel. How are you going to defend your assertions of privilege before the court? I always think about that when I'm writing up my written discovery objections and responses and also making a privilege log. While there's always some give and take before you actually get to that point of an oral hearing with the court on your discovery requests and opposing counsel's objections, you've really got to think, is this going to hold water, or am I going to look like I'm abusing these privilege designations rather? And as Jennifer had also touched on, you know, your credibility as an attorney and appropriately using these tools in our toolbox. And one last topic that I had wanted to get to today is more so in the vein of protective orders and how to mark documents confidential or attorney eyes only, that share some common principles, of course, with asserting privileges. And not all protective orders are created equally. I'm sure we've all got protective orders that we prefer to use or have for a certain client, let's say, and there's generally a back and forth process of negotiating what stays in and what doesn't in a protective order. Or if you have a client with specific needs about their certain business practice, making sure that's included. Of course, some of our courts also offer us a form protective order. So that's a great starting place to look as a resource. If you're starting from scratch, take a look at the court's website, whether it's Just Text for the Harris County District Court judges or the federal judges pages. They're a great resource if you need something. So of course, first place to look if you're practicing in a specific court. And you've also got to just know the language of the protective order, both in negotiations and after, so you can appropriately explain it to your client and any experts or consultants that you're working with, including document vendors, to make sure you're covered in enforcing the protective order for that sensitive information. And what I really wanted to get at here was thinking about when you make those notations, are the documents really confidential, or do they really warrant that designation that only attorneys outside counsel can see the documents? And it again gets at the credibility issue of how are you going to look when you go before the court if you need to have a discovery hearing on these issues. You also may have more leverage with opposing counsel if you used your designations sparingly in making your own production, because once you're doing the doc review of opposing counsel's production, you'll probably have a bit more room to push back if you don't think something's really AEO and you want to share it with your client on the corporate side. So things to think about in making those decisions. Always a good practice to reach out to your client as well to determine, hey, is this really confidential, especially as a young lawyer and getting to learn your client's businesses, or does it really need that heightened protection of AEO, or would it be okay if this document was reviewed directly by our opponent? With that, that's the formal portion of our presentation, and I will open it up for questions if anybody